If you have applied for a Canadian visa, work permit, permanent residence, refugee protection, or any other immigration application, and you later realized that based on the recommendation or advice of your agent, you misrepresented information, this message is very important for you. First, you need to clearly understand one thing. Even if the misrepresentation was done based on the advice of your consultant or agent, the legal responsibility ultimately rests with you, the applicant. Canadian immigration law makes it very clear that every applicant is responsible for the truthfulness and accuracy of the information submitted to the government. However, if you were genuinely misled and your agent improperly guided you to submit incorrect or incomplete information, there are legal steps you can take to reduce the damage and to create clear distance between yourself and the individual who directed you to misrepresent. One of the most important actions you can take is to make a formal, documented report to the appropriate authorities. Doing so may demonstrate that you did not intend to deceive and that once you became aware of the issue, you took proactive steps to correct it. These authorities include Canada Border Services Agency, Immigration, Refugees and Citizenship Canada, College of Immigration and Citizenship Consultants, and if the person advising you was a lawyer, the relevant provincial law society. In your report, you should clearly explain that advice was given to you, what information was submitted when you discovered the problem, and what steps you are now taking to correct the situation. Keep copies of any contracts, messages, emails, payment receipts, or written instructions that show you relied on the advice. Here's something extremely important. Do not gamble with your future and your children's future. If you become inadmissible to Canada, your child, your dependent child, and a spouse also become inadmissible to Canada. And because of misrepresentation, there is a very strong likelihood that you will face serious difficulties in other major immigration countries as well. This can include the United States, the United Kingdom, Australia, and New Zealand. Immigration authorities in these countries often review prior refusals and findings of inadmissibility, and a negative record in one country can significantly affect applications elsewhere. Ignoring the issue or hoping that it will never be discovered is a very risky strategy. Misrepresentation can lead to refusal, multi-year bans, and long-term consequences that follow you and your family for years.